I noted that some of the examples that you cite were courts, maybe arguably, putting their toes on the line of Rule 8.1115. In your practice, and we're all attorneys here, if you were to consider doing that, citing an unpublished case to show a fact or to show that something, maybe you can give an example. Would you do that just by putting a citation, or would you do a request for judicial notice?
Well, I personally would not do that. I wouldn't cite an unpublished opinion given the state of the rule as it is currently drafted. But we note in the opinion that, or in the article, that the current practice among courts, both courts and litigants, they do this. They do cite unpublished opinions just to identify relevant facts from other cases. But if you're asking what my practice would be, I don't do it at all. I don't know if David has a different practice.
I do. I have cited it. I don't know. I've done it in petitions for review. I don't know whether I've ever done it anywhere else. But petitions for review, if you want to show that an issue is recurring in the courts of appeal, it's an accepted practice, although in violation of the letter of the rule. It's an accepted practice to cite unpublished opinions to tell the Supreme Court, hey, there's a lot going on under the surface, not just published cases, but this issue is coming up a lot in unpublished opinions too. Yeah. And that's an accepted practice, but it violates the rule, which is the whole point of the article. We're just trying to get the rule to coincide better with the practice.
I thought I had recalled that citing unpublished opinions in a petition for review to show that the issue is coming up was one of the exceptions provided for in the rule. Is it not?
It is not, and that's one of the main points of the article.
I had missed that. I don't know where I got that into my head, but that's okay. Good to know.
Yeah, it's done all the time.
How else would you show that the issue that this is ripe for review if you can't show that, look, all these other courts of appeal are tripping over this issue every which way?
Well, I mean, if you were going just by the way the rule is written right now, the letter of the rule, you'd be restricted to show just published opinions dealing with that issue.
Or maybe you can get a student to draft a law review article about all these unpublished decisions and then cite the law review article.
That has been done.
You're kidding.
Not by us, but I remember when I was clerking at the Court of Appeal when I was first out of law school, where a brief cited a law review article, and in that law review article was a discussion of an unpublished opinion that was right on point. And I said,
a useful public service.
I said, "Oh, that's a very clever way to get around the rule."
I like it. I'm not the only scofflaw around then.
And that's scofflaw is the word that I think of. The point of the article is to save practitioners and the courts from being habitual scofflaws when they cite to these unpublished opinions.